Welcome to Bridging the Gap, Law, Therapy, and Justice.
Welcome to Bridging the Gap, Law, Therapy, and Justice. I'm Caitlin Burgess, attorney and licensed marriage family therapist. My work blends law, mental health, and forensic insight, helping families in courts navigate emotionally complex situations with structure and clarity. Today, I have the honor to be joined by Jason Wright. He is the founder of the Law Office of Jason Wright, PLLC in Austin, Texas. Jason focuses on complex family law and custody matters throughout Central Texas. Today, we're talking about a very timely issue. It is interstate custody and family law disputes, including what happens when parents live in different states, how courts determine jurisdiction, and the legal complications that can arise when families move between places like Texas or California, between Texas and California, for example, during or after separation. Welcome again, Jason.
Hi, thanks for having me. I appreciate it.
So, Jason, I'd really like to know what are some of the most common custody disputes that end up involving more than one state in your experience?
I would say that
Sure.
it's a fairly common question that comes up a lot as far as where that's going to be or what state is what. But I'd say the most common part where it initiates or starts is you've got, people with a military family, military service, or work that makes them travel, things of that nature. Uh, Oftentimes if someone has moved to a new state, right, because of a job or something, but they're where they used to live is where they have all the family, or they moved from where they used to for someone's job. So now they're in, for instance, Texas, but all of their family and whatnot is in California. The issue really comes down to, is it pre-filing or post-filing? Those are two. That's a big fork in the road, because before something has filed, there's no rules. I mean, in the sense of those are married people doing married people things, and people make agreements, and so someone can move back to Florida or Texas and file, and the rest of the family's in California, and now we have a jurisdictional issue that we're fighting about. But and there's a different analysis that goes into that based on a variety of things, versus they've lived here in Texas, right? They, husband was stationed at Fort Hood, and they've been in Texas and they've filed now, but they want to go back to California, or someone is trying to claim that they really lived in California, that kind of thing. Those are common fights.
I see. So do you get priority if you file first, like for that jurisdiction? Let's say you move to Texas, for example, and the rest of the family is back in California. Do the courts consider priority like that?
So there's a federal statute that governs this interstate jurisdictional issue. It's called I call it UCCJEA, but it's UCCJEA, the Uniform Child Custody Jurisdiction and Enforcement Act. And it's a federal statute that kind of outline, and I believe every state has adopted some form of it, or the language exactly from it. In Texas, we have we use that, it's a particular chapter in our family code, and so it outlines, the fact patterns as I presented them. Right, they had lived in Texas, they've been living in Texas, but mom and kids moved back to California and filed. Right, then there becomes, now we're doing an initial jurisdictional analysis. We're trying to decide where's the proper venue for us to be arguing about this case. And the courts are under that statute, there's a different analysis, but one of them is going to be, what is the child's home state? What is the home state been established as? And there's criteria that goes into evaluating that, and then whether that state is the correct state to take the case. Will jurisdiction go to that state, or will it retain? And in Texas, for instance, or will it go to California? Was Texas the home state, and is it more proper for the court to retain it here in Texas, or was the home state really California? For a variety of reasons, they're looking into the various aspects of that. Now, a caveat to that is well, let's say non-emergency divorces, right? Non-emergency pleadings, right? These are people that just are wanting to separate or wanting to, versus an emergency pleading where there's abuse or there's an allegation of something that has caused the parent to flee to another state. That has a different analysis, and it establishes a different type of predicate to whether or not the it may not be in the home state, but the reason they have now fled to the state and this new state may be the most appropriate forum to hold this based on the allegations that are being made, right? The emergency actions of abuse, or they're trying, there's a safety issue regarding the parent and or the child, and so that gets into the analysis of which state is the proper venue for this court.
Good point. Yeah, definitely abuse situations. I could see how that would trigger a different analysis. So, Jason, what legal or procedural mistakes can create problems when a parent moves with a child before the custody issues are fully resolved?
So here in Texas, you know, under that fact pattern, right? We either, we've established where we're going to be. We're in Texas. We're fighting a case in Texas, and most of the time, like I practice law in Central Texas, which is Travis County, Williamson County, and Hayes County, and each one of those counties have what they call standing orders. That the judges of those counties got together and said, okay, when a lawsuit is filed, these are the rules until we make new rules or until we get into court, that kind of stuff. And several of those counties have a rule that says you can't leave the state with the child without permission from the other party. And so if in that scenario, if right at the beginning of a case in a county with that standing order and they leave, well, they're in violation of court order. And that can be an enforcement that can trigger lots of other things that the parent who has left the state might not be in a good position. If we've got temporary orders in place in Texas or in my counties, temporary orders are often, I'd say most of the time, people come to an agreement. But if we have to go have a hearing and a judge has issued temporary orders, almost exclusively they're going to establish what we call a geographic restriction on the parent who had. So in Texas, we don't necessarily use the word custody when we're talking about these issues. We have conservatorship, which deals with who gets to make decisions. Parents are presumed to be what we call joint managing conservators, or get joint decision making power. Possession is the word we use. We don't say visitation or custody. We say possession. You made these things. You get to possess these things, is what I say. And so, when a court is going to issue, a right that a parent has is the right to determine the primary residence. That's probably one of the biggest things that we fight about. A court is going to give a geographic restriction, an area in which the parent and the children cannot leave, and the whole purpose of that is to keep children close to the parents so they can exercise possession in a timely fashion. And so if that has been established, let's take the previous example, right? There has been a geographic restriction. There has, orders in place, and a parent then leaves the state in violation of that order. One of the analyses under the UCCJEA is if a parent is leaving that state, even if it's an emergency action, and they're doing so is violating a court order, the analysis of that, they're not going to give credit to the party who is violating a court order to try and establish jurisdiction in another state or to establish something in another state. So, but even if they weren't trying to establish a new jurisdiction, if they were just wanting to go to, they want to now live where their parents live or live next to family, right? If there's a court order and they've left, that's a big problem. And they are putting themselves in potentially, in Texas, when you violate a court order, it's enforcement. It's what we call a quasi-criminal action. You can be faced with civil contempt, criminal contempt. There are real, I'd say, big boy penalties for violating a court order and taking a child across state lines. So it's a big no-no. Obviously, we don't encourage that type of activity, but that is some of the biggest things that a parent who, if rights have already been established and orders are in place in the middle of a custody dispute, they go and do that, they are potentially flipping the court's perception of them. The court's going to look at them in a much different light when we're evaluating potentially a final determination of these things.
Interesting. Also interesting the vernacular that you use in Texas that I didn't realize it wasn't custody visitation, but actually you use the terminology possession, which is not something we are using in California where I practice.
What I say is, no one visits their child, right? So we do not have visitation rights. We have possession rights. We have conservatorship rights, and so that the vernacular is something that I spend a lot of time training my clients about because TV, internet, people they I almost exclusively people say or come in thinking about visitation, and on the flip side, mothers might be saying, "I don't want him to have any visitation," and a father might be coming and saying, "I want equal visitation." And so I'm trying to help them understand you're not visiting your kid; you're parenting them when it's your time.
Yeah, and I think that's an important distinction. Sometimes parents who don't here in California, I've worked with parents who don't have, the same amount of parenting time and they don't like to be told that this is their visitation. They like to be use the term custodial time share, which I think is important, right? Because you're parenting your child. So that's interesting, the vernacular that's used in Texas. So why do you think, Jason, the relocations cases become so emotionally and legally complicated, even when a parent believes they're acting in good faith?
Well, I guess when I think about that question, I think about which parent thinks they're operating in good faith, right? The parent that is wanting to move, rarely like the point. Obviously, if they agree, it's not an issue, right? Their parents can do what I say is parents can do pretty much anything under the sun if they agree. But if they're in my office and we're talking, then we clearly don't agree. So, the other parent, it's very common for I'd say that let's say the parent who's moving or wants to move, right? It's pretty rare that the parent wanting to move is just randomly wants to move to Virginia, right? They want to move to Virginia because that's where their parents are, or they have a support network, or there's usually I would say a good faith reason that they're wanting to like they didn't want to come to Texas. They went to Texas because of the other person's job or something like that. And so usually there's not a lot of I would say bad faith motives on the person wanting to leave, but the issue becomes the other parent doesn't agree. The other parent has a job here, or the other parent has their family here, or another common problem we have is they have a child with another person, right? We have two children, one with this spouse and one with their ex-spouse, and they can't leave the state because they have a child with someone else. And so the idea what the perception is, regardless of the motive behind the parent wanting to move, is that you're trying to take my child from me or away from me. And I'm only going to see them, you know, best case scenario on holidays in the summer. And so, I'm dealing with the most primal things that people can be fighting about, right? Their kids and their money. And so when it comes to the idea that someone's wanting to move their children away from them, emotions get high, things get personal. People don't really, well, their logical eyes kind of take a break and they see things from a different venue. And so part of my job is to help them, you know, pull back from that and not get supercharged and not react to everything. But that's probably one of the biggest reasons is the perception that the other parent is trying to take the children from them.
Yeah, it can get very complicated, very emotionally charged. So, once two states become involved in the same family law dispute, do these courts communicate or coordinate to prevent conflicting custody orders?
Yeah, almost exclusively, yes. I mean, my experience has been judges will schedule times and talk to each other. I've had judges, you know, not obviously in open court, but they will take things under advisement or, I'm filing a brief today on a case, dealing with an interstate issue. So in the event that the judge maybe isn't, it's not that they don't know what they want to do or not, but sometimes, and I've found if there are two courts, right, we have two. It's not a situation where someone's trying to move. We have two courts that someone has either filed something in, or we have two judges in a case. They're almost my experience has been they're almost always going to call each other and they're going to have a conversation. And I'm obviously not privy to what that is, but my sense has always been that here in Texas, like jurisdiction is not we the way we say it is it's not that one state takes it from the other; it's the other state relinquishes it. And so my presumption has always been that it's usually not a very controversial call that they kind of work out in their mind as they understand the law, and then they make that call. But it's almost always been my experience that they're going to communicate with each other.
Excellent. So, Jason, what happens if one parent files in Texas, for example, while the other parent is already involved in a case in California? I guess that's when the judges call each other again.
Right. That's when the UCCJEA is going to come into play, right? Because once someone has filed, it also it depends. If it's an original filing, the first filing was in California, then someone comes over and files something in Texas. Now we're dealing with the UCCJEA, and the issues about this is an initial pleading. The idea of home state. What was the child's home state? Where have they resided? Where are the facts of this case? Things like that are going to come into play, and then that's ultimately, I do think the courts are going to. I'm trying to think of an example where the court made a decision without contacting the other judge, even if it was just a checking my math kind of phone call. It's just been my experience that they do that, and so, but that's how that's going to go down. Is something's already been filed in one state. Uh, file a lawsuit, answered, or just been served. The other person runs over to another state and files and said, "No, this is the proper state." That's when the analysis is going to come in. And for an initial pleading, it's going to have a different analysis of like, what is the home state? Why are we disputing where they live and where the jurisdiction should be?
So let's get back to emergency custody situations again, because as you probably know, having worked in family law for the majority, or I think all of your career, I believe, and I've worked in family law for decades now, and there's domestic violence allegations, sometimes substance abuse, even criminal. The case can simultaneously be involved in the criminal courts. So let's go back to these emergency custody situations again. So, and you may have touched on this, but I just want to be clear. So, what happens when there's an emergency and a child is located in a different state from where the original case was filed? So, let's say someone has to flee with their children. So, what happens in that situation?
Well, one of the first things that has to happen, and part of this analysis is what they're pleading and what the allegations are. Is it abuse, abandonment, mistreatment? The issue, the crux of that issue is there a threat or a safety issue to the party and or the child? That's the centerpiece of the analysis. Um, you know, Emergency jurisdiction can be established temporarily. It can be very narrowly tailored. We're going to take up emergency jurisdictions because we have this fire we need to put out, and the fire could be that there's actual abuse or actual, um, it's a very serious matter that we don't want to punt back or take under analysis. Like, okay, they've met the requirements under the statute. They have an affidavit that outlines all these various elements. We're going to establish emergency jurisdiction to then maybe make some temporary orders, maybe make some initial decisions, and then we can go and analyze what would be the proper venue moving forward to finalize the case, or then is temporary emergency authority going to get us here, and then what does that do to carry us forward to the other elements of the case, right? I mean, then again, if it's an initial pleading, we got home state jurisdictions, we have jurisdictional formalities that we're looking at that we would normally look at. But when you have an emergency, you do have the ability to establish, at least temporarily, a temporary emergency jurisdiction based on the threat. And then we go back into our other analysis after that, maybe after things have calmed down or initial temporary orders have been issued, that kind of thing.
Okay, I've got one more question for you. What should parents focus on if they are dealing with custody issues across state lines and want to avoid creating bigger legal problems for their themselves later?
Well, by far, I mean, don't violate a court order, right? Once, regardless of what type of order, right? If you've been served with a lawsuit, like for instance in Travis County or Williamson County, when you're served a lawsuit, the standing orders are going to be attached to that document that you've just been served with, and it's going to list out, don't do this, right? Don't leave the state, or don't change bank accounts, don't cut off phone service, things like that. But when we're dealing with don't leave the state, if there's an order you've been served with that says you can't leave the state, if you regardless whether you have an emergency, right? And what I tell clients sometimes is, look, I'm a parent, you're a parent. If you feel that you need to protect your child, you need to act, but you need to understand that potentially when you're in family court, a judge who doesn't know you, and in our state we elect our judges, so someone who's been elected who may or may not have any experience with family law. There's no requirement in our state that a judge who's in a family court has any experience with family law when they get elected judge. And so you need to be prepared to stand before that judge and answer if that judge disagrees with your parenting decision to protect your child. And so what I'm saying all of that, meaning if you've been served with something that says don't leave the state, and then you leave the state, even to a setup with emergency jurisdiction, because you believe you have what you need to do that, understand that we're already starting here because it's a divorce and we're not getting along, you're kicking it up. That is, we are now taking this case to a much more aggressive manner. Can we get back down? Possibly, surely, but it's starting the case at a much more aggressive nature. And if you don't prevail, if the court isn't sympathetic to your position or doesn't agree that there was an emergency, or sees you as acting in bad faith, the consequences that could be pretty rough. From an aspect of, from Texas, you might get your decision-making power limited. You might get your possession time limited. You can have joint decision-making power in Texas and have limited possession and access to your child. Those are two independent, separate things. And likewise, you could have an equal possession schedule, but have no decision-making power, right? Those are things that happen. And so if you are seen acting in bad faith or violating a court order or doing something that, this third-party person in Texas who's been elected thinks that you're acting in bad faith, the consequence could be rough. So I would highly recommend not doing that, talking to a lawyer before you act, because if you hire an attorney and you tell them the facts, that they have the ability to file a motion. They have the ability to get to the court's attention and bring your facts to the attention of the court in a way that is proper. And while it may not be, it's still civil litigation. It doesn't work as fast as people want it to. There's problems with it, but that is usually the better way than taking it into your own hands, leaving the state, and creating a much different problem.
Yeah, following court orders, going through the proper legal channels. Great guidance there. And we have run out of time, Jason, for this episode. Thank you so much.
Thank you.
So that's all for today's episode of Bridging the Gap, Law, Therapy, and Justice. To learn more about my practice and my work at the intersection of family law, mental health, and forensic practice, you can visit my website, CaitlinBurgess.com. And to learn more about Jason Wright and the law office of Jason Wright, PLLC in Austin, Texas, visit jasonwrightlaw.com. Thanks for listening, and don't forget to like, subscribe, and leave a review, and share this episode with someone who may find it helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.